We were on the brink of a monumental national crisis due to a willful assault on our democracy by a set of judges who abandoned the law, judicial precedents, and sound legal reasoning to pursue interests suspected to be pecuniary. But all thanks to the Supreme Court, who rescued the country and restored hope in our democracy by the sound judgment delivered on Friday, January 12, 2024. Across the country, many elected officials lost their freely given mandate in suspect judgments in which the election tribunal, petition tribunal, or court of appeals assumed jurisdictions over matters it has not. But there happened as pockets of cases, grave as they were to democracy, till the monumental disaster which swept off nearly all the mandates given to the People's Democratic Party in Plateau State. And this was in addition to the vexatious judgments in Kano and Zamfara states. The security and political tension peaked at this point. Everybody who is in Nigeria knew what the situation was, what the kind of tension was prior to the Supreme Court settlement of these issues. What the justices of Court of Appeal, led by Justice Freda William Dawood, who presided over the cases emanating from Plateau State, did was horrendous. It remains one of the greatest assaults on democracy in Nigeria. It was indeed a brazen judicial haste, and coming from the judiciary, it is unacceptable. It must be repudiated, it has to be remedied, and this includes also those involved in the attempted judicial banditry in Kano and Zamfara. The justices that are culpable should have no place in our judiciary. The thought that this set of justices may one day find their ways to the Supreme Court is horrifying. It should not happen at all. If the justices that will give this kind of judgment in the Court of Appeal are now to be the ones who will now hold everybody's faith in the Supreme Court, it can only be imagined. It shouldn't happen in this country because we will be at very high risk. For the records, these justices unjustly sacked 2 senators, 5 members of House of Representatives, and 16 State House of Assembly members in one state, Plateau State. There was no reason in the Nigerian laws to have done that. No reason, because the Supreme Court, in handing over their own judgment, said there have been a plethora of settled cases from which they decided to forget what the Supreme Court has settled. We have every reason to believe that justice was deliberately miscarried. Imagine the crisis that would have been ravaging Plateau now if the case of Governor Caleb Mutfwang were to be terminated at the Court of Appeal, like those of the House of Assembly and National Assembly. This is how much crisis a set of careless and perhaps compromised justices would have caused the country. This would have been the same case in Kano and Zamfara states. The country would have gone up in flames because these judges or justices, both at the tribunal level and the Court of Appeal, decided to do their own thing. For instance, in Kano, there was almost a consensus between non-partisan lawyers and laymen that the strange deduction of over 165,000 votes from the NNPP and Abba Yusuf to pave way for a roundly defeated APC and Yusuf Gawuna is a judicial coup, because it amounted to punishing the party, their candidate, and the electorate for the error of INEC and its officials. It was also inexplicable to hold that only the NNPP and Governor Abba Yusuf benefited from ballots that were unstamped, unsigned, and undated. The other ground for obtaining the victory was based on party nomination, which the Supreme Court has dealt with, saying in a plethora of cases, according to that Supreme Court. It was a strange judgment that insulted the sensibility of Nigerians, and those judges of the Tribunal and Court of Appeal who attempted that coup in Kano must be punished. They must be sacked, investigated, and maybe prosecuted. That should also be the case for the justices of Court of Appeal that attempted to thwart the will of the people in Zamfara. In fact, in delivering his judgment, the Supreme Court described the judgment of the Court of Appeal as perverse and lacking in evidential foundation. That is, there was no evidence of irregularities in places the Court of Appeal ordered a rerun. It means that the Court of Appeal manufactured its own evidence. This is how stinking these judgments are. It is also important to note a few of the points raised by the Supreme Court concerning the decision of the Court of Appeal in the case of Plateau State. Justice Emmanuel Agim, who read the lead judgment, was emphatic in stating that the Election Petition Tribunal and Appeal Court lacks jurisdiction to entertain pre-election matters. Justice Agim further stated, "We have heard in a plethora of cases that the sponsorship of a candidate for election is an internal affair of a political party. The Court of Appeal lacks the jurisdiction to determine the validity of the candidacy of the PDP. Iwata of APC has no right to challenge the emergence of Governor Mufwang as a ticket holder of the PDP." That is, the Supreme Court said many cases has already been decided. The Court of Appeal decided to now set their own precedents over the Supreme Court. Those justices cannot say they don't know what they are doing. Because even we are laymen know that where Supreme Court has decided, you don't dare. Therefore, if the Supreme Court affirms that it has heard in a plethora of cases that the issue of nomination of a candidate rests with the political party, where then did the Court of Appeal find its own superior position? Or were they trying to overrule the Supreme Court? This case here oozes a stench, no matter how one tries to look at it. In fact, the Supreme Court went further to dismiss the argument of the Court of Appeal about non-compliance with an order of the Plateau High Court to conduct fresh Congress before conducting primary election. He said that evidence showed that the order was complied with, and that even if it was not, it does not stop the PDP from nominating its candidate. Either way, by Supreme Court standard, either way, all the argument about non-compliance, it was, even if it didn't happen. Again, the justices clearly erred. It is for them to say why they took the decision they took that is causing the political turmoil in Plateau State today. Consequently, it is obvious that the Court of Appeal justices went out of their ways to manufacture their own arguments to miscarry justice. We cannot pretend that this is a case of mere mistake or differences in legal opinion. There is a total lack of confidence in the Court of Appeal as we speak, especially against the backdrop of how they were severely berated by the Supreme Court. This look more like a judicial hatchet job. The judiciary should be rid of justices like this, both in the Court of Appeal and in the tribunal, as in the case of Kano State. They should be sacked now before they mess the entire system completely. This clarion call is on the National Judicial Council to act with dispatch and firmness. Nigerians are waiting for a firm and definite action. The world is watching. In spite of the brilliant intervention of the Supreme Court, the judiciary is in a mess as far as this matter is concerned. The MJC must act to clear this mess. This is not a matter to be swept under the carpet because a lot is at stake. We and other pro-democracy groups will keep vigil on this matter. Justice has to be served to those affected by this disheartening judicial outcome. Thank you very much. Igwe Ude Omanta, convener.
Again.
Igwe Ude Omanta, convener.